Contract Law, taught by Steve Presbury. It is a 2-hour core class. So I just need to run through the requirements for this class as set by the Utah Division of Real Estate. And I apologize because I know most of you have heard these rules, but you must have your camera on and be present in front of the camera for the duration of the class. This does not apply if you don't want credit. You're welcome to listen in, but I will monitor, and it is subject to you being on camera. You also will be given 3 keywords during this class, and I will share with you as soon as I'm done talking here a link, and then I will share it again at the end of the class. This is where you will fill out your details. Please don't rush to fill it out, but read the directions, because we do require that you fill out certain things in a certain way. And then you will input the 3 keywords. And so we can only give credit if you follow these rules. If you miss a keyword, they won't be given again. So reach out to me through the chat and I can assist you as long as you have been consistent with the rules thus far. So I think that is it. Did I miss anything, Steve?
No, that sounds good.
Okay, so enjoy the class, and I will share with you in the chat the link for the form that you will not be able to complete until the end of the class. But we asked that if you could fill that out today so we can register your credits. We like to do that the same day. Thank you so much. And if you have any questions, feel free to chat me privately through the chat that you see along the bottom of your screen. Thank you and enjoy the lesson.
Leslie Ann?
Yeah.
Do we need their name, full name?
Oh, Daniel, I missed something. Yes, I had seen that. Sorry. Your name must be displayed. I'm seeing some phone numbers and something that says iPad. I need to know who you are. So if you can go onto your name, click on the top, you should be able to change it to your name. If for some reason you can't, you'll need to send me a chat and say, I'm showing as this, but my name is, otherwise we can't give you credit. So please make sure your name is in full on the screen, or let me know if for some reason you cannot figure out how to do that. Okay, thanks, Steve.
Thank you, Leslie Ann. Welcome to Presidio Raising the Bar. Certainly welcome those of you who join us for the first time, and also welcome those of you who are brand new agents. And I should just quickly go through the rules again, just to make sure we're all good. See if I can get my little machine to work here. So this is a core class, so it'll go towards your 9 hours of core that you need to keep your license active. Leslie Ann's mentioned, full name on the screen. Keep your video turned to the on position so we can see you. Must be seen and engaged for the duration of the class. The Division of Real Estate requires that you're in attendance for the whole of the class to receive your credit hours. I'll give you 3 keywords during this presentation, and at the end you'll be able to submit those on the form that you'll receive. To remind me, this is our little dog Merlin, who'll pop up, remind me that I've got to give you a keyword. Try to make that simple so that I don't miss those out. So raising the bar, that's our little motto, or our slogan, our objective, our target here at Presidio. And I'm sure those of you who are with us from other brokerages may have something similar, that you try and increase the performance of your real estate work within this industry. I found this really interesting quote that I thought I'd like to share with you. It's from the 6th president of the US, John Quincy Adams. This is what he said. He said, if your actions inspire others to dream more, to learn more, do more, and become more, you're a leader. And I think as we do that, we don't just think you're a leader of other people, but you're a leader of yourself. If you can inspire others to become better from where they are, then I think we are automatically a leader within our own rights, because we're inspiring others to raise their bar. Now, this this topic is probably a little bit boring for most of us. It's one that we have to have. So I'm hoping that you'll chime in and give me some of your thoughts and stories and experiences that we can share with other people. We've got about 37 people on this lesson, this class, and many of you are very familiar with the REPC, very familiar with the REPC and contract law. So as we go through this document, let's see if we can highlight certain things that maybe we've learned from, or maybe we've not understood fully. Maybe we can share thoughts and comments for other people. There's a lot of reading in this, so I'm going to ask, as I go through this, if there anybody would like to read a slide. I think that would help us to be more connected, listen to some other voices. So please feel comfortable doing that if you're able. So first of all, let's have a look at the first part of this. Right at the very top there, underneath the real estate purchase contract, we talk about the earnest money. And it's interesting, just before we get to that, we have that little note that says this is a legally binding real estate contract. We know it is the REPC, REPC. Utah law requires real estate licenses to use this form. Buyer and seller, however, may agree to alter or delete its provisions or to use a different form. If you desire legal or tax advice, consult your attorney or a tax advisor. So this has been created by the best lawyers in Utah, and this is the form that we use. Now, what's interesting about this little form is right at the very beginning, we have this little offer in here has got a date. This reference date is something we need to be familiar with, because whatever we do with the REPC from now on will have a reference to this date. So if we were creating a real estate purchase contract today, which is, I think, the 10th, isn't it, today? Is it the 10th? I think it is the 10th. I think it's the 10th. Nobody's commenting on that. Have I got the date right?
No, it's the 9th.
It's the 9th. It's the 9th today, not the 10th. I'm ahead of the race, gain a day. It's the 9th today. So we would put in there the 9th of March, 2021, and then anything else that was going to be referred to this contract would have that date in their reference. So there we have the buyer's name, offers to purchase from the seller's name, the property described below, and agrees to deliver no later than 4 calendar days after acceptance, as defined in section 23, which we'll cover later, an earnest money deposit of the amount of, in the form of. So we'll put a dollar amount in there. Often the earnest money is being given in the form of a check, but it could be a wire transfer, or it could be some other form of delivery. After acceptance of the REPC by the buyer and seller, and receipt of the earnest money by the brokerage shall have 4 calendar days in which to deposit the earnest money into the brokerage real estate trust account. So there we have it. Anybody got any comments on this slide or anything they'd like to add or share with regards to this part of the REPC? Okay, I'll give you a question then. As we're talking about earnest money, how much earnest money should we give on a price of a house? Anybody got any ideas on that? Obviously, they can give whatever they want, but if a buyer asks us, what do you suggest we give as earnest money, what would be our answer? Let's have some responses to that. How would you answer that question? There's bound to be someone that's thinking about an answer on that. Someone says to you,
1% of the purchase price.
Sarah, thank you for responding. 1%. I think that's a good thing. That's what I usually say. 1% I think is reasonable. I think it shows some commitment. The earnest money obviously is a little bit of skin in the game. Anybody else got any other ideas or suggestions other than 1%?
I would say not more than you're willing to lose should something go wrong with the contract, and also considering later on in the contract where it talks about how earnest money is also the amount of liquidated damages as certain ways to rectify the breach of a contract.
Very good, Ian. Thank you for sharing that. However, we may just put a little sub comment there, and that is, if we're looking after our buyer carefully, there's no reason why we should ever lose any earnest money, should we? You know, if we're looking after them, we shouldn't ever be in a position that they'll lose earnest money. The earnest money should be safe. Obviously, we need to make sure that they're fully aware of the deadline dates that earnest money is sitting on. Now, let's talk about the market today. At the moment, we're in kind of a seller's market, and we may approach this earnest money with maybe some other different approaches. In some cases, we may suggest, you know, you might consider offering more than 1%. Why would we say that in this type of market?
Show that they're serious about it.
Okay, particularly, thank you, Christy. Particularly if they've got, you're in a place where it's a, you know, maybe a $250,000, $300,000 house, and you know there's going to be many offers in. If you've got a little bit more earnest money, you may have a chance of being high in that pile of interest. So in some cases, we may want to give more than 1%. We had a client that gave much more than that on one time. I think it was started at $10,000 and it went up to $20,000 because they desperately wanted this house and they did not want anybody else to take it. They put in as much earnest money as they possibly could, and it did actually give the sellers certainly an interest in them, and they did actually buy the home. But earnest money is always protected if we look after them, but certainly the more earnest money you give, the better the offer can be received. You've only got three things to work with anyway. You've either got, well, you've got your price, your offer, you've obviously got your earnest money, and then you've got your deadline dates. They're the only three pieces of the puzzle that mean anything to the seller. So earnest money is important. Yes.
Another point to maybe make on that too is a lot of times you can't make your offer look stronger price-wise because of appraisal constraints. So you can go ahead though in almost unlimited really in terms of what you're putting down for the escrow. So, or excuse me, not the escrow, but for the
earnest money. Yeah, a very good comment there. Yeah, we can't push the price up too much because it will not appraise unless, of course, it's a cash buyer. So it's interesting that on this contract, the first thing we talk about, the first thing the seller is going to see is the earnest money. And so very important we get that right. And it certainly gives the seller an opportunity to see how keen we are on buying that property.
You say that, but at the same time, just like you said, earnest money is always protected if you have a good agent. I mean, I think it's not necessarily the earnest money, it's how quickly the earnest money goes non-refundable. Yes. Right. So I had one that offered $265,000 in earnest money, but it was a larger deal, right? I'm going through it right now, and she was saying, "Hey, we're very intent on this. We're doing everything. We really want this." And so I said, "Great, then make it 7 days until it's non-refundable." So that to me, you can put however much earnest money you want, but as long as it's protected, it doesn't matter until they put their skin in the game.
Yeah, very good. Thanks for raising that, Brandon. We just had a contract where we had it's not completely finished yet. It started off beginning of the month, and they desperately wanted this house, and the seller said, "Okay, we won't show the house to anybody else if you give us some non-refundable earnest money right from the get-go." And you know, they had just a few days, and you know, a sizable amount of money went non-refundable. So it locked the buyer and the seller into the contract. Very good. Any other comments on earnest money?
I was gonna say, I just made an offer on one for a client yesterday. And we went 50,000 over asking price, still didn't get it. And the agent told me that somebody put 20,000 non-refundable earnest money from acceptance, and they decided to do with them. So I'm like, how do you compete with that? First time home buyers can't compete. So it's just frustrating. You just, I don't know. It's hard to even win one for people anymore, unless you're going to go crazy like that.
Ashley, thanks for sharing that. That's a chunk of earnest money going hard. But I guess they want the house, and that's what they're trying to do in this seller's market. You know, you can use earnest money as a little bit of a lever to put you in a good buying position.
I also think,
very good. Yes.
I think there's one other thing that actually protects the buyer in this market is if they put in a large amount enough earnest money deposit, then if a better offer comes along to the buyer and they want to cancel the contract, it's going to be a little bit more painful if they have to, you know, give back the earnest money and the equal amount. That kind of protects your buyers of having someone come in and try and renegotiate behind the scenes. I mean, hopefully that doesn't happen, but it does, right?
Right, very good. Yeah, so there's a bit of skin in the game for both here, isn't there? Both the seller and the buyer, locking them into the account. Very good. So earnest money is really important, helps us to start off the contract on a very strong platform, and hopefully with strong commitments from both parties. Let's move down to the property. So, anybody like to read that for me? Have we got a reader? Must be a little reader out there. Okay, have to be the English guy then. All right then, so we're going to put in here. Okay. Or did someone say something?
I said I could read it for you if you wanted, but go ahead. We like your voice.
No, I like to hear you, Brandon. Come on, let's have you read it for me.
Okay. So I'll skip to after the property. So you just want any reference below to the term property shall include the property described above, together with the included items and water rights, water shares, if any, referenced in section 1.1, 1.2, and 1.4. Want me to continue?
Yeah, let's just go to the end. Perfect.
In 1.1, included items, unless excluded herein, this cell includes the following items if presently owned and in place on the property: plumbing, heating, air conditioning fixtures and equipment, solar panels, ovens, ranges and hoods, cooktops, dishwashers, ceiling fans, water heaters, water softeners, light fixtures and bulbs, bathroom fixtures and bathroom mirrors, all window coverings including curtains, draperies, rods, window blinds and shutters, window and door screens, storm doors and windows, awnings, satellite dishes, all installed TV mounting brackets, all wall and ceiling mounted speakers, affixed carpets, automatic garage door openers and accompanying transmitters, security system, fencing, and any landscaping.
Super well read, Brandon. Thank you for doing that for me. That's quite the list, isn't it, Brandon? Have you noticed how detailed that is?
Yeah, and the one that really gets everybody lately, well, over the last couple of years, is the installed TV mounting brackets.
Yeah. Yeah, because they could be quite expensive if you've got to buy them yourselves.
Steve?
So, yes.
What does landscape mean? Did you hear me?
So, the fencing and the landscaping. So they're really talking here about, you know, what we would call fixtures in the landscaping. I know one client we had, they wanted to take some particular rocks with them that were part of the landscaping, and we had to exclude those because, you know, they were part of the landscaping. They had some special meaning for them. And so, you know, when we're selling a home, whatever the landscaping is, and those rocks and boulders, it includes those, and anything else that's fixed in there. There may be a waterfall, or there may be some cameras or some lights, anything that's part of that landscaping, that it would be included in this sale. Does that make sense?
There's one other thing there as well. It can include as much, just as what Stephen was saying, but it can also include like a rose bush. So when I was doing the brokerage training just recently, there was actually an example that was given where a sell was in dispute because the seller had removed, and I don't remember, it wasn't a rose bush, but there was several types of plants that they had that were kind of passed down through generations, and they removed them, and the buyers wanted those plants. And so there was a dispute based upon that, and there had to be a resolution made over plants.
Yeah.
I think
exactly
the
right.
I think the key here is to explain to our sellers that if there's anything that is in this list, to remove it before they list the home, or to be sure to spell it out as an exclusion. You know, my thought is that if you've got a really expensive TV bracket that you want to take, then remove it and patch it up like it was never there, because then any buyer is not going to know that it was there. So the key is to remove or exclude. And if you don't do those things, as Brandon said, you could run into some major troubles.
Yeah, I know we sold our home in Harriman. We had like a little orchard there, lots of different fruit trees. I was a bit sad to leave them actually. But anyway, we also had a framework that carried a net that we would put over these fruit trees in the summer months to stop the birds helping themselves to their fruit before we got them. And we took all that down. Sorry, someone okay? Someone to comment? Yes, someone's speaking, Leslie. I can't see her name. Can you just ask her to unmute?
Linda Hardman.
Oh, maybe she's got some technical challenge there. But yeah, we removed the framework and the netting before we listed the home, so it was never seen. Very good. Something we have to put on this form, and it can easily be forgotten because we obviously don't know it without looking it up, and that is the tax ID number. Often we can put in the property address and the city and the county and the zip code. We kind of got that, but we can sometimes forget that tax ID number. So make sure you get that in there. It is part of this form and it's easy to look up with the tools that we have online. Before we go to point 1.2, any other comments or thoughts on this part of the contract?
Can we see if it's working now?
Oh, there we go. Yes, welcome.
Thank you. Thank you. It's Linda Hardman. One thing that I've had an issue with is if you're looking at storage units in the garage, it's often a great idea if the agents will take a picture of what actually is in the garage, because most sellers, they just think they can take whatever, it's not in the house. But I've had a resolution because of pictures that have solidified clients, the sellers, to bring back what they took.
Very good. Yeah, very good point that is. Taking photographs is a good idea, particularly if we're further in this contract talking about excluding items. We can indicate on the photograph the items we are excluding if it is a plant or a bush or a storage unit type. Very good. Thank you for sharing. All right, let's move on. Here we've got them all. This sometimes can be a little bit not confusing, but interesting that we get it correct, because it says here other included items, and it goes on to say to check the appropriate box. And we've got the washers, dryers, refrigerators with an S on the end, and microwave ovens. Now, sometimes a seller may think, yeah, I'm including the refrigerator in the kitchen, and I'm also including the one that's in the basement that's got the little mother-in-law apartment, but I'm taking the refrigerator home that's in the garage, okay? And if we notice that this one does have an S on the end, it does mean any washers, any dryers, any refrigerators, any microwave ovens, they're all plural. So we need to make sure if they've got extra appliances that are maybe in the garage or in an outbuilding or somewhere else they're thinking of taking with them, we're going to maybe have to make sure we exclude that item.
Stephen?
And of course, yes.
You know, again, if you're doing your job, it would be a really good idea to not only write down serial numbers, but take pictures like we've talked about of the refrigerators and whatever's there, because sometimes the seller will want to exchange a DI refrigerator for the nice refrigerator that they have in there. Just a thought.
That's a great point. I like that idea. Put in the, you know, the serial number. It could be the same with a TV as well, or any electrical device, so that it's clear what they're getting in the deal, particularly if it's a large home and they've got multiple appliances. Very good. Thank you for sharing that, Randy.
But that is only appliances that are being left. Most people don't leave TV. So it's only if they,
Yes,
if it
that's
shows
correct.
that it's included, not,
Yeah.
we should, yeah, okay.
Yeah, so I probably should have said a movie screen. I was thinking theatre TV, but yes, absolutely. And then we obviously make sure that we've got to indicate if we are including additional or not including additional property items on those two blocks there. And then we need to make sure on this screen, I just put a note here, just make sure this is absolutely clear when we're working with our seller, that they know what they are retaining and what they are selling. So we make it absolutely clear to any buyer. I know we had a transaction a few years ago where the buyer took, I think it might have been a refrigerator, or maybe it was a washer, I can't quite remember. Anyway, but it was one of these grey areas that had not been absolutely clearly identified in this document. It was an extra item and we had to tidy that up, but the appliance was up a flight of stairs, so it wasn't going to come back. And then, you know, we had to figure out a way of crediting financially. So we just need to make sure we get this piece clear in this document, because it can save a lot of heartache down the track. Any other comments on that slide? Okay. Let's move on to water service. And I had to learn about this when I came over from the UK, because it's very, very different over there than it is here. So the purchase price for the property shall include all water rights, water shares, if any, that are the legal source for sellers' currently water service and irrigation water service, if any, to the property. The water rights, water shares will be conveyed or otherwise transferred to buyer at closing by applicable deed or legal instruments. The following water rights shares, if applicable, are specifically excluded from this sale. Do you have anybody on this class that have actually had some challenges with water rights and transferring the property ownership of water rights?
I haven't had challenges in transferring it. I mean, it is a separate bill of sale outside of the contract. Yeah. If it is to be sold, even though it says it's to be included there, it is something that is like I said, it is outside of, and an appraiser will not value that as part of the real estate. The one thing that you have to be very critical of or really look into is if you are transferring water shares or rights, that there's not a requirement by the city to have a certain amount that stays with the property.
Yeah, very good point. That is very good point. Thanks for raising that. I've just put this information up for you, just for those of you who may be new to this or just joined this industry. The Utah Division of Water Rights administers the preparation and distribution of the state's valuable water resources, both surface and underground. And then we've got that little logo down there. Anybody know what that logo stands for? The DNR, Utah DNR. Oh, just to remind us.
Natural Resources.
There you go. Yes, Department of Natural Resources. Perfect. So that's where we would go if we needed some little help on that. But very important, we figure that out. And if we've got a seller who doesn't know about the property and whether it has or has not water rights, then we can contact either Utah Division of Water Rights or the DNR to find out accordingly. Any other comments on the water service? Okay. Oh, Merlin's up.
That would also be the responsibility of the title company to make sure that the water rights themselves are in the name of the seller, and that if the property had changed hands in the family, that it is still contiguous to the property.
Very good point. Thank you for raising that. Yes, absolutely. Absolutely. Okay, so there's our keyword. I made it easy this time. Water. WATR, water, is our keyword. That'll be the first keyword for this class, water. Okay, now we're getting down to the good stuff here. It's just like playing Monopoly. I thought that was a good little visual to put in there. So we're going to buy this property, and we're going to indicate on this part of the form how the money comes in to pay for it. Now, I put a note here to say it's really important that we make sure that these figures all add up. Okay, because if they don't add up, it's a bit of a problem. We need to make sure that we've got the right amount of earnest money in there. And if we are going to be putting some additional earnest money, which we'll cover later on in 8.4, we'll slip that in there as well. And then obviously we've got the loan, and then any addendum to the financing. And then we've got the cash that's coming in at settlement. And all those lines, A, B, C, D, E, should give us the full purchase price. Anybody had any difficulties with this section, or any things we ought to highlight that we ought to be careful of and watch for that I'd like to share? Oh, okay. Well, this is quite an important section. We get it right. And it's really good for the seller to see how these little areas add up. Sometimes as a buyer's agent, we can be a little bit, I have seen buyer's agents, so they just put the purchase price in there and the earnest money, and they've not been bothered to figure out the bits in between. I would suggest if we can figure out those little pieces in between, it's much nicer for the seller to see all of that. We're being totally transparent, and it will certainly help them in making their decision as to who they would give the purchase of the property to. Any other thoughts on? Yes, thank you, Mike.
It seems like oftentimes you don't exactly know what the new loan amount will be, or these things kind of fluctuate between the time you present the offer and when you actually close. So I'm just wondering, kind of how binding are these categories in terms of the contract? I mean, you've never had someone come back and say it didn't match, but it's almost an estimation, I feel like.
Yeah, as far as I understand, sorry, you go ahead, my dear.
Yeah, they're not. You can revise these as long as they are actually capable to close on the product. This is just an estimation of how they could purchase the property. But be careful with number E, because you want to see that someone's putting skin in the game. Even on a VA, they're most likely going to get money back.
The last sentence on there says any amounts shown in section 2.1C and 2.1E may be adjusted as deemed necessary by buyers and lender.
Exactly.
Very good. Thank you, Ben. Yeah, how I've always looked at this is, if we're the buyer's agent, we should be as transparent as we can, and we give whatever information we have. And of course, as the transaction progresses, we can strengthen whatever we've been able to share or update it. And as Ben just highlighted, all of those areas between C and E can be adjusted. Very good. Are we all good with that slide? And thank you for your comments on this. It's really important. I know we've got some very well-versed and senior agents on this class, but we also have some very new agents. And sometimes, a new agent, when they look at this purchase, this real estate purchase contract, it can just be mind-blowing. So it's really good to hear your comments. Thank you for that, and also stories and thoughts, because it enables them to let the information settle into their minds. I know when I first saw this form, I thought, my goodness, I'm never going to figure out how to fill this in. So thank you for sharing your comments. We really appreciate that.
Can I also say something? I was talking to an agent the other day. He was the list agent, and he's telling me that they have so many offers, which is what is happening right now, and that his seller was a D personality. So he was looking for absolute perfection in the contract. And his seller chose the contract that they went with because it was without fault. Plus, the agent was extremely responsive, and the agent gave highlights of the offer in the email. But going back to what we said, even though this area can change, to some sellers, they may think, oh, that's missing. So I think my thought is, even if we end up changing it, that filling out that with what we know could mean the difference of a seller that's presented with numerous offers in accepting your offer. Just a thought.
Very good. Thank you, Leslie Ann. All right. What about this, eh? So 2.2, sale of buyer's property, buyer's ability to purchase the property to obtain loan reference in 2.1, see above, and or any portion of the cash referenced in section 2.1e above is or is not conditioned upon the sale of real estate owned by buyer. If checked in the affirmative, the terms of the attached subject to sale of buyer's property addendum apply. So we've all seen this. They want to go looking for houses before they've even got their house on the market. They fall in love with their house. All of a sudden it's, well, let's get that house sold fast. So we need to help our buyers understand that if they do find a property that they are going to have ultimately contingent on the sale of their property, that they have got to be able to be prepared to price the house to sell. Otherwise, it's not going to happen. Any thoughts on this comment? This little part of the REPC. Any people had some stories they could share where they've seen this go a little bit off target and someone's loved a house, but they just can't sell the house quick enough? Okay, you probably have. We certainly have had, where we've had to say you've got to price your house to sell, otherwise, you know, you're going to lose the house that you're under contract for. Okay, so we move on to the next one. Very good. Settlement and closing. 3.1. Have I got a volunteer who'd like to read that one for me?
The settlement shall take place not later than the settlement deadline referenced in section 24D, or is otherwise mutually agreed to that buyer and seller in writing. The settlement shall occur only when all of the following have been completed. A, the buyer and seller have signed and delivered to each other, or the escrow closing officer, all documents required by the REPC, by the lender, by the title insurance. And the escrow and closing officers by written escrow instructions, including any split instructions if applicable, or by the applicable law, or monies required to be paid by the buyer or seller under these documents, except for the proceeds of any loan, have been delivered to the buyer and the seller, to the other party, and to the escrow closing office in the form of cash, wire transfer, cashier's checks, or other form acceptable by the escrow closing office.
Wonderfully read. Thank you very much. Cool. There's a lot of juice in that. A lot of juice in that little paragraph. And thank goodness we've got the title company looking after us to get all those pieces of the puzzle in place. I think that's fairly clear. Does anybody have any questions on any part of that part of the contract? I would just mention that just be careful. As you notice, this follows two sheets. It goes from sheet 1 to sheet 2, and it's easy to forget those buyer signatures and dates at the bottom of every sheet, particularly for new agents. Just remember you've got to have the initials at the bottom of every sheet. Any questions on statement and closing? Okay, we're all good on that one. Very good. We do refer to this a little bit later on the closing. And here it is. For purposes of the REPC, closing means that A, settlement has been completed. Yay! B, the proceeds of any new loan have been delivered by the lender to the seller or to the escrow closing office. And C, the applicable closing documents have been recorded in the office of the county recorder. Recording. The actions described in 3.2b and c shall be completed no later than 4 calendar days after settlement. So here's a couple of things we need to be thinking about. Many of our clients think they're going to a closing. In this state, they go to settlement. The job is not closed until we've done the settlement and the funds have moved, the money's got to where it needs to get to, and the title has been recorded with the new owner. That's when it closes, okay? That's when it's closed. I've had some clients come out of settlement and think, okay, where do we get the keys? We're closed. I said, we're not closed. You've just attended a settlement. And that's good because we're nearly there. But we have a few extra things that happen before we close. And sometimes, you know, we've got lenders that are actually contacting employers just to make sure that, you know, Sam Smith has still got his job there. And there are times when, unfortunately, we can go through a settlement and the transaction not close because of some difficulty with one of these items, which is usually the lender. Any thoughts on that slide, or comments, or things to add? Just to make sure that you remind your clients that we're closed when we've done our settlement and we've funded and recorded. And thankfully, we'll always get a note from or a call from the title officer who will tell us when it's funded and recorded. We can call our clients and say, hey, you own the home or you sold the home. Okay, let's move on to this 3.3, which is possession. Do I have a volunteer who'd like to read that one for me?
I'll read it.
Wonderful. Thank you, Christy.
Except as provided in section 6.1 A and B, seller shall deliver physical possession of the property to buyer as follows. Upon recording, blank hours of recording, blank calendar days after recording. Any contracted rental of the property prior to or after closing between buyer and seller shall be by separate written agreement. Seller and buyer shall each be responsible for any insurance coverage each party deems necessary for the property, including any personal property and belongings. The provisions of this section 3.3 shall survive closing.
Perfect. Thank you so much. So there's a couple of pieces in there that we just need to be aware of. What will we highlight to our client on this? Can you see a couple of items that we do need to just remind them of on this?
That, you know, just because it has recorded, maybe they may not get it upon that. It may be hours or days after the recording for them to actually get their keys.
Absolutely. And sometimes they can forget that they've agreed that from the outset, and they get all excited about moving in the home. So, oh no, we've actually got 48 hours before we're going to get into this home, and this was the reason we agreed with this. Oh yes, okay, right. And of course, they've just got to remember when they're organising their platform, even though the deal was done, they're not going to get that key to the property until we've gone through whatever has been agreed on possession upon recording or after recording or calendar days after recording. And also to remind them that whatever is done here, it must be done in writing. Does someone else have another comment? I heard something. Okay, perfect. Any other comments on this slide? Yeah, the deal is done and the buyer gets the keys and we finally get possession. Okay, so here's an interesting one. Prorations and assessments. Anybody would like to read that one for me? Do I have a new reader out there? Okay, you have to have the English guy. Oh, I have got a reader.
Prorations,
Thank you,
assessment. You're welcome. Other payment obligations. 4.1 prorations. All prorations, including but not limited to homeowners association dues, property taxes for the current year, rents and interest on assumed obligations, if any, shall be made as of the settlement deadline referenced in section 24D. unless otherwise agreed to in writing by the parties. Such writing could include the settlement statement. The provisions of this section 4.1 shall survive closing. 4.2 Special assessments. Any assessments for capital improvements as approved by the Homeowners Association, HOA, pursuant to HOA governing documents, or as assessed by a municipality or special improvement district prior to the settlement deadline shall be paid for by seller, buyer, split equally between buyer and seller, or other. The provisions in this section 4.2 shall survive closing.
Perfect. Thank you so much. I do like to hear you ladies talk, so thank you for sharing your good voices with us today. I'm pleased that we have the title company that tidies up all this, because this could be a nightmare if we were having to do it ourselves. But we do need to figure out if there are some special assessments that are going to be dealt with by the buyer or seller, or equally divided between both of them. I'll put a note on this one that we just need to be careful. Let's see if I got it on here. So, whoop, that's not there. You need to be careful that we don't overlook this, because dividing these costs and expenses between the buyer and seller are very important, particularly if some of the costs are large costs. So let's have that discussion with our people. With another comment, Jessica? Yes, fire away. Thank you.
Yeah, so just something to be aware of that I've ran into recently is keep in mind a lot of times an HOA may do a special assessment and maybe the homeowner needs to pay $100 or $200 per month. So if that's marked seller, a lot of times a seller is not going to realize that if it's a $10,000 assessment being allocated over a monthly payment, that actually will need to be paid at the time of closing.
Yeah, and that can end up being quite a bit of juice. So yes, very good. Thank you for highlighting that, Jessica.
Another thing you can put in there for clarification is that if any are attached to the property, because you may not know, there are some even subdivisions that have some CNR
yes,
things that are relative. And so by protecting that, it says if any are attached to the property.
Yeah. And some of them can be sizable amounts of money. So it's good to have that discussion.
Exactly.
Very good. Thank you very much. This one here basically covers, we won't go through this in great detail because we've kind of covered a little bit already, but just let's be careful for those high HOA fees. Sometimes we've got a percentage that's got to be paid at closing, and we've got to make sure we know who's paying that and how it's being taken care of. The important part of this section is that we at least have the conversation with our purchaser, so they know what they're going to be paying. They always want to know what they're being paid at the end. Often the purchaser has got a budget and they're trying to fit within this. And if some of these extra fees are going to stretch them out of that, we need to have that conversation from the outset. Anybody else got any comments on fees, costs, payment obligations, which is this in the previous slide combined? Okay, very good. Let's move on to the next one. Confirmation of agency disclosure. This is quite important, and it's important you get your license number in there, and obviously your real estate brokerage license number in there. Make sure you check the correct boxes, and this is fairly simple to deal with. Buyer and seller acknowledge prior written receipt of agency disclosure provided by their respective agent that has disclosed the agency relationships confirmed below. So this is all part of the document. Make sure this is clearly signed. Any comments on that slide? Okay, we're doing well. Okay, let's talk a bit about title. Have I got a reader for this one? Who'd like to have a crack at this one? Okay, You have to have the English guy. Maybe I should ask Leslie Ann to read it. You might get a Cockney accent then. Leslie Ann, are you there? Do you want to give them a bit of the London chatter on this one?
You're a beggar. The other problem is my glasses. I need them. Okay, so number 6, title and title insurance. Is that the one?
That's the one, yeah.
Oh my goodness, it's so small. Okay. Seller represents that seller has, okay, I can't, sorry.
Sorry, I didn't realize you got the wrong glasses on.
No, let me just see if I can enlarge it.
It's okay, I can do it.
Sorry, yeah, I can't, I really am struggling to see.
No problem.
Oh, hang on a minute. No, I've done it. Okay. Seller represents that seller has fee to the property and will convey marketable title to the property to buyer at closing by general warranty deed. Buyer does agree to accept title to the property subject to the contents of the commitment for title insurance. The commitment provided by seller under section 7 and as reviewed and approved by buyer under section 8. A, long-term lease or rental agreements. Buyer agrees to accept title to the property subject to any long-term tenant lease or rental agreements, meaning for periods of 30 or more consecutive days, affecting the property not expiring prior to closing. Buyer also agrees to accept title to the property subject to any existing rent. Oh, no, sorry.
That's right. It's rental and
Fine,
property
closing. The provisions of this section 6(1)(a) shall survive closing. Do you want me to read B?
Yeah, if you can see it.
Short-term rental bookings. Buyer agrees to accept title to the property subject to any short-term rental bookings, meaning for periods less than 30 consecutive days, affecting the property not expiring prior to closing. The provisions of this section 6(1)(b) shall survive closing.
Perfect.
Wow. I kind of
Sorry,
think your remark was a little sexist when you said you enjoyed the women talking. You've just kind of basically frightened off any guys from reading.
No, they'll come up. I've got plenty of time for them to shine.
Okay.
So yeah, this is really important, and it's important that we understand if there are any other rental connections to this property, that they're all included on this title insurance transfer. Has anybody had any challenges with this area they'd like to share a story or a comment or a thought about? While you're thinking about that, I just put a note up there for those who are brand new in this game. Title refers to a document that lists the legal owner of a piece of property. Titles can be issued to depict ownership of both personal and real property. But thankfully, we have the title companies that really look after this area for us. But if we've got any lease rental agreements within this contract, then we need to make sure that we are including them within these within this this REPC. Any comments on that before we go to the title insurance, which is slightly different?
I do have one short story.
Yes, thank you. Life
so
stories.
I'm currently representing a seller, and the husband and wife are getting a divorce and buying separate properties. And one thing I hadn't thought of until I discussed with the lender is that if they've filed paperwork for divorce, that they can't close on their house until that has all been finalized and there's a divorce decree that says what, where the proceeds need to go, etc. And luckily my clients hadn't filed their papers yet. So I don't know if this is good or not, but I was like, maybe hold off filing those papers until we get your house sold. And then you can carry on with that, because that would have really tied things up a bit for them.
Yeah, thanks for sharing that, Tara, because I've not heard of that before, but that could really delay not just weeks, but months. That could be a serious challenge for them.
Yeah.
So yeah, very good, very good. Thank you for sharing.
Hey, Stephen.
Yes, thank you, Steve.
I want to point out that this is, well, at least as I've been paying attention, at least the second item in the REPC that has said that we will survive closing. I think all the agency to know which sections survive closing.
Very good. Yeah, thanks for sharing that. Yeah, it may even be the third actually, but yes, you see the survive closing at the bottom of several of these sections, which is good to know. Okay, let's just a reminder, get your initials at the bottom of that page 2. Easy to miss because this form follows on. It doesn't finish after one section. It's in the middle of a section. You go to the next page. So it's easy to miss those initials. Title insurance is a form of indemnity insurance that protects lenders and home buyers from financial loss sustained from defects in a title to a property. So I think we're all fairly familiar with that one, but that's what your title insurance is for. That's what you're paying for, that settlement. Any comments on that slide? Okay. Let's talk about seller.
That people, oh, sorry. Can you just
carry
make
on.
sure that they know the difference between a standard policy and an Eagle and an Alta? Sometimes builders will only do a standard.
Yes, they do. Yeah. Do you want to just show them tell them the difference between the standard and the Alta?
Exactly. Yes, a standard policy just covers the last owner, but an Eagle or an Alta goes back to where the property was actually dirt before a hole was even dug to protect you from any liens or encumbrances on the property.
Yeah, very good. Thank you for raising that. Excellent.
I have a follow-up on that. How do people ever have issues with title companies only going back to when electronic records started in the state of Utah? Because I've tried to push a couple different title companies to go back as far as Linda just referenced, and a lot of them kind of give pushback and say it's either not really important or the state of Utah only requires they go back to when electronic records started. Has anyone else run into any of that?
That's a good question, Ian. Any comments on that one? I mean, I've seen title companies who have photographed documents and put them into an electronic file, you know, photographs, but I've not heard of them going back to hard copies. That's a good question.
And the fee is not really that much more either when you're looking at a standard policy versus a Alta or an Eagle policy. There really isn't a lot of difference for the protection that it could afford.
Right, very good, very good. Thank you. Okay, let's move along. So the time is about halfway through. Okay, we probably need to step up a little bit now. Sellers disclosures, really important, this one is. Let's make sure we get those sellers disclosures in as soon as we can and make sure that we are covering all of these areas. Without reading through all this, is there someone out there who would like to just summarize this little section for us? Anybody like to summarize this one? Okay, maybe I'll pick on someone. I'll pick on Steve Perry. He's our regional director at Presidio, and he's got a wealth of information. He also serves on, I think, some sort of judiciary platform, don't you, Steve? Tell us about that, Steve. See if you can share some light on this section for us.
You want me to read it or just talk about it?
Just summarize. Just talk it through.
All right. So the seller property condition disclosures are the documents that the sellers provide to the buyers that say what work and don't work on the property to the best of their knowledge. When filling out the paperwork, the seller fills it out. The agents absolutely do not fill this paperwork out. You can sit there and maybe help answer questions, but they're the ones that fill this out and sign initial the bottom of each page and sign the back page. There's also a place for any updates. If something happens whilst the property is under contract, you have to disclose these issues as well to the buyer and get the update signature signed on it. This does include all HOA minutes, CC&Rs, title commitments that you're supposed to provide. These are all supposed to go along with the seller disclosure. So if you have a property that has HOAs and things like that, they do need to be sent over at the same date and deadline. It's all included in this. Lead-based paint disclosures as well follow underneath this. That has to be sent over in the disclosure in the same timely manner under that.
Perfect. Thank you, Steve. And thank you for highlighting one area that I did want to share on this, and that is that we do not fill out the seller's disclosures. I would encourage you, when you've got a client who's looking at selling a home, give them that checklist early on. In fact, you know, as early as you possibly can, so that they can go through it, get it all ready and done, even before the house is listed. So you've got those seller's disclosures you can give to a potential buyer quickly. It's important they're accurate, and it's important that every line is dealt with. If you've got a line that is either it's not a yes and it's not a no, then you'll need to still put a cross through it, or you'll put down not applicable, but you need to make sure that the buyer knows that you've dealt with every line on that checklist. And many of our brokerages are very good at making sure that they're completely filled out, and very good. And some of those things will be difficult for us to, as a seller, to deal with. Some of them make us happy, some of them make us a bit frustrated, particularly if we've had a flood or something in a basement, we've tidied it up and it's all clean and tidy now, but we've still got to disclose it. We've still got to say, yeah, this happened, you know, the water tank leaked and we got it fixed, and then we include the, you know, I guess the paperwork or the invoice or certificate, whatever it may be that we've got from the contractor that got that particular problem fixed. So seller's disclosure, very important that we're totally honest. Okay, I like this, but buyer's condition of purchase. All right. I want to just talk about how much time you think we would give for due diligence. I think if that was our home, we might not be giving them any time on due diligence. We'd probably think we were done. But sometimes the inside of the home can look a bit like that. It might look pretty good outside, but inside the home, there may be some issues that may need some attention that we can't see from the outside. You know, there may be some mold, or there may be some termite, or there may be some foundation cracks, or maybe a problem with the roof, or whatever it may be. But we need to be able to deal with this early on. And often, you know, we can get an inspector in there to look after this home, as far as if there are any safety issues or any repairs that need doing, or general maintenance. Often we as a buyer can't see what we could see in this photograph because it's all behind the walls. So here's a question: how much time do you think we should encourage our buyers to work with to get their due diligence done? Any thoughts on that? Because obviously they're going to pass a deadline date, and that earnest money is going to go hard for due diligence on that date. Any thoughts on what sort of time we might suggest? Not set in stone, but a rule of thumb. So if we're going to close on a house within 30 days, what would be reasonable for a due diligence?
Right now, people are wanting like 7 to 10 days.
Yeah, you're absolutely right, Ben. And in some cases, even quicker than that. But yeah, 7 to 10 days is pretty usual. Any other comments on that?
Stephen?
Yeah.
Lately, we've actually, in this market where we're seeing creative offers come in, we've seen some where they've, if they were excluding the
not conditioned,
the appraisal deadline, they're actually putting this deadline closer to closing, so that in case the property doesn't come in, even though they've excluded it, they could still withdraw due to the buyer due diligence. So it's kind of sneaky, but it works legally.
Yeah, and obviously, I mean, you've also got the other side of the coin, because it's a seller's market. If you're pretty confident this house looks reasonably good, you could go with the is not conditioned. That may give you a stronger platform of being chosen to be the buyer of the house.
Well, yeah, and you have two exit points too. You have the due diligence and the financing and appraisal. So you can exit at either one of those. So as a buyer's rep, you could consider those.
Yeah, I'm glad you raised that, Randy. We need to be careful. I know there have been in the past some agents that have not really worried about the due diligence, because they think, oh, we can just jump out on the financing, and somehow they work out the financing doesn't work. And we shouldn't be in that neck of the woods. We should be, if we are passing that due diligence date, when we're saying, as far as we can see, this property is good to go, we're happy to buy it as is, we'll only pull out if the lender seriously cannot qualify us for the financing. And that's the correct way of doing it. But I have seen in the past some agents that have, don't worry about due diligence, we'll just pull out at financing if we don't like the house. And that's not what we should be doing. Any comments on that or thoughts on that slide? Okay, let's move on. There's a lot of juice in there. And, particularly in that second part where it says if applicable, water source, and it goes on to say HOA dues and utility costs and all that jar. Make sure you understand that with regards to any damage of the property that's being involved in this contract. Oh, okay, so Merlin's back. That means we've got another word here. Keyword will be conditions, CONDITIONS, conditions. That'll be number 2 keyword. So if you want to jot that down, that'll be your second keyword, is conditions. Okay, buyer's right to cancel or resolve. Time to say goodbye. So if buyer determines in buyer's sole discretion that the results of the due diligence are unacceptable, buyer may either, 1, no later than due diligence date referencing, or B, cancel REPC by providing written notice to the seller. Upon the earnest, money will be released to the buyer without the requirement of further written authorization from seller, or 2, no later than due diligence deadline referencing 24B, resolving right of the seller any objections buyer has arising from buyer's due diligence. And C, failure to cancel or resolve objections if buyer fails to cancel the REPC or fails to resolve in writing with seller any objections buyer has arising from buyer's due diligence as provided in section 8.1, buyer shall be deemed to have waived the due diligence condition and except as provided in section 8.1, 8.3, 8.2, 8.3, the earnest money deposit shall become non-refundable. So make sure you've got these dates clearly listed somewhere so that you know when they're coming up, and your client knows that if they pass that due diligence date, then that earnest money will go hard. Okay, any comments on that slide, on that section of the REPC? Good. Appraisal condition. This is kind of a challenge at the moment because we are having properties, because there's so many properties out there on the market. We're having offers coming in that are in some cases maybe higher than the value of the property. This could be a challenge when they get an appraisal in there that it won't appraise for the amount they are hoping to purchase the property for. So buyer's obligation to purchase the property is or is not conditioned upon the property appraising for not less than the purchase price. this condition is referred to as the appraisal condition. We're also finding at the moment appraisers are probably taking a little bit longer than general just because they are so busy. So bear that in mind. Buyer's right to cancel. If after completion of an appraisal by a licensed appraiser, the buyer receives written notice from the lender or the appraiser that the property has appraised for less than the purchase price, buyer may cancel REPC by providing written notice to the seller. No later than the financial appraisal deadline referenced in section, and then upon the earnest money will be released to the buyer without further written authorization. Okay. That little piece at the bottom there, failure to cancel. If the REPC is not cancelled as provided in this section 8.2, buyer shall be deemed to have waived the appraisal condition and except as provided in section 8.1, B and 8.3 BI, the earnest money shall become non-refundable. That's really painful when that happens if you don't want it to be non-refundable. Anybody have any stories where unfortunately the buyer has lost the house and lost some earnest money on this section? Good. Means you're looking after them. We as agents shouldn't really lose any money if we're looking after our clients. Any questions or comments on that slide? Very good. Let's move on. Oh yes, just remember your date at the bottom there. It's another one that covers 2 sheets, 1 section. Easy to forget them. Financing condition. All right, so I've got quite a bit of stuff in this one. But obviously, we need to make sure we know if it's going to be conditioned on financing or not. Some properties or some buyers are not. They're happy to buy it. Maybe they're going to buy cash, or maybe they just know they're going to purchase the property and then maybe do it up and resell it, flip it, or whatever it may be. But it's important that your buyer understands this little section here. If they are going to be based on finances, then they've got right up until that financial date, deadline date, before they can pull out and retain their earnest money. So on this one, we got no financing required, which is great. I think I've only dealt with one of those. Generally, people need a mortgage or a lender to help them buy the property. And then you've got the buyer's right to cancel before the financial or financing deadline, appraisal deadline. You've got the buyer's right to cancel after the financing and appraisal deadline. And you've got the earnest money deposit released to the seller. So let's look at that. Buyer's right to cancel after the financing and appraisal deadline. If after expiration of the financial and appraisal deadline referenced in section 24C, buyer fails to obtain the loan, meaning that the proceeds of the loan have not been delivered by the lender to the escrow or closing office as required under section 3.2, then buyer shall not be obliged to purchase the property. Buyer or seller may cancel the REPC, providing written notice to the other party. So who can give me a for instance when this might take place? Has anybody seen this take place after settlement? I presume it could take place after settlement. If for some reason the lender found out that the buyer lost his job, maybe. Anybody got any thoughts on that? Ian, you're giving me a nod. How about giving me a comment on that?
You took my example. I was just going to say they're calling basically the same day as settlement now to ensure people still have their jobs. So I could foresee that happening if someone had lost their job. Yep.
Yeah, so it's nice that it's in there, a little bit of protection there, but that could happen. Very good. Anything else on that slide anybody would like to share a comment on or a thought? Okay, I think we're doing quite well. It's such a boring topic, isn't it? I'm trying to make it exciting. I'm not doing very well, but I'm doing my best. So additional earnest money deposit. A little bit more money in the game, a little bit more skin in the game for for the seller. So the buyer says, I'll pay you some extra money. If you choose me, I'll give it to you maybe after the due diligence, or maybe give you some more at the financing and appraisal deadline. But this basically says if the REPC has not been previously cancelled by a buyer as provided in sections or applicable, then no later than the due diligence deadline or the financing and appraisal deadline, whichever is later, buyer will or will not deliver to the buyer's brokerage an additional earnest money deposit in the amount of whatever. The earnest money deposit and the additional earnest money deposit, if applicable, are sometimes referred to herein as the deposits. The earnest money deposit or deposits is applicable shall be credited towards the purchase price at closing. Certainly in a seller's market, if a buyer wants to have a stronger offer, they can offer a little bit more extra earnest money, and even non-refundable earnest money would be also attractive to the seller. Any comments on that slide? Very good. Okay, this is important. Obviously, if we're presenting a REPC and we've got some other information that we need to add to it, we would include it with the REPC, particularly if it was a, FHA loan or whatever, we'd add it in here. Or we may have a lead paint addendum or whatever it may be. We can add other addendums to the REPC right from the outset, and of course continue to add addendums to the REPC in the course of the transaction. I made a note here that we don't ever change any of the wording in the REPC. We would always use an addendum to change what the REPC stands for. So if we're going to plus stuff or minus stuff, more or less, we're going to use an addenda to change that. Any comments on that slide? Very good. Just remember, whatever we change to the REPC, we need to have it in writing, signed by both parties, and we'd use the appropriate addendum for that. Also, make sure when you're creating your addendum, you're either going to go by numbers, you could go by a title, but just make sure they are all different. That's the key thing. When the title company looks at addendums, they want to make sure you have not got two addendum 3s, or you've got two addendums that have got the same title. They've got to be different, separate title contracts that are attached to the REPC, if that makes sense. Any questions on the addenda? Okay. I thought that was quite a nice looking house, actually. Reminded me of the house I used to live in England. It didn't look the same shape as that, but it was in stone. Leslie and I lived over there up until about 12 years ago, and we left a 400-year-old farmhouse. So this house had been sitting there for 400 years, and it was stone. The stone was 16 inches thick. And I remember drilling through it once, and that's quite the drill because it was stone. But this house caught my attention. So it was quite a nice house to show. Big stone house. Home warranty plan. So what is a home warranty plan? For those who have just joined this industry, at a minimum, a new home warranty plan generally includes deposit insurance and protection against defects in work and materials, as well as major structural defects. So this is quite a nice little one. Maybe we'll read this one through. I've got a little reader who'd like to read that one for me. Maybe someone who's out there would like to read that for me. Give me another accent on the job. Maybe one of you gents could read it. Well, you've all gone quiet on me. It's bound to be someone out there. All right, then. You'll have to just deal with the English guy. Unless I can squeeze someone out there. The trouble with these Zoom meetings, I can't really get to, interact and, feel of you. I have to look at your screens, and I can only see 3, 4, or 5 screens here. I can't see all 30 of you. All right, so let's have a look at it then. Home warranty plan, 1 year home warranty plan will or will not be included in this transaction. Now, often we'll include these, and often we'll invite the seller to pay for the plan. That's usually how we'll do it, and we'll invite the buyer. Often we'll choose it and select from which company the plan will be selected from. And then there'll be an amount of money where it says there, home warranty plan shall not exceed, there'll be an amount of money that it will not exceed. Generally speaking, these are probably going to cost around $400. Sometimes a little bit lower, sometimes a little bit higher, depending on the size of the home. But in general platforms, often they'll be included. The buyer will choose the type of plan they want. They'll choose the company that will provide the plan, and the seller will often pay for it. Now, that's not always the case, but I would say in my experience, that's more than not the case. Does anybody have any other comments they'd like to share on this, or any other experience or stories?
There may also be a home warranty that is existing on the property already. And so the remainder of that year could go to the buyer, the new buyer.
Yeah, very good, very good. And obviously, if we've got that, it'd be nice to indicate that on the MLS report so that people know that they're already getting part of a warranty that's already planned into the property. Yeah, thanks for highlighting that, Linda. Very good.
And if there is any money left over that the seller could benefit to the buyer, they can also use that for an extra year. I've had that happen as well. If they've reached the amount of closing costs, I know not in this market right now, but let's say that they're willing to pay $3,000 in closing costs and they can't use anymore, you can manipulate the extra for an additional year.
Yeah, very, very good. Yeah, excellent. And also, sometimes when they're transferring a policy like that over to a buyer, they can be benefiting some of the lower rates rather than going into a brand new policy. So that also can be an added benefit. Very good, great comment. Any other thoughts on this slide? Okay, let's talk about the condition of the property. Seller acknowledges and agrees that in reference to the physical condition of the property, right, the seller agrees to disclose in writing to the buyer defects in the property known to seller that materially affect the value of the property that cannot be discovered by reasonable inspection by an ordinary prudent buyer. So that's get our inspector there to do that, but they're also going to disclose that on that seller's disclosure checklist form. Carefully review, complete, and provide to buyer a written seller property condition disclosure as stated in section 7A. Deliver the property to the buyer in substantially the same general condition as it was on the date of acceptance. It's really important. Obviously, there may be a little bit of ordinary wear and tear, depending on how much time there is between the acceptance and receiving the property. But generally speaking, it needs to be the same as the buyer saw the property and decided to buy the property. I like this bit. Deliver the property to the buyer in broom clean condition, free of debris and personal belongings. I remember I had to buy a property. I'd never seen a house so cluttered. In fact, it was beyond belief that anybody could live in a house like that, and it was more beyond belief that they would leave the house like that. But it clearly says here that it should be broom clean and free of debris. We had to talk to that seller, and we eventually got them to pay for the buyer to have, someone come in and clean the house because it was left in an awful state. And then what does it say there? Repair any seller or tenant moving related damage to the property at seller's expense. And there you've got that. Provisions of section 10.3 shall survive at closing. So let's just make sure, particularly if we are representing a seller, that they understand they're going to leave that house broom clean, free of debris. I remember I had another client. I was representing, unfortunately, the seller on this one, and they'd done their best to clean out the house. You know, I think they'd done more than that they would generally do. But the buyer that came in was not happy that the house was not as clean as he has expected it. And I had to explain that the seller had done their very best. And there was still, he didn't like the dust. He opened up the cabinets, you know, in the kitchen. He said, look, this is all dusty. And I'd say, well, you know, it is broom clean and they have done their best. But it was a difficult moment because the buyer was expecting the property to be spanking clean, all shiny, you know, and it wasn't. But it was broom clean, and it was free of their stuff, all the debris, but he didn't like it that the cabinets, the kitchen cabinets, have still got dust in them. So we just have to make sure that we help our clients understand what they're going to expect on the condition of the property. Any thoughts or comments on this little slide? Or any strange stories? Yes, Linda?
I just wanted to add that for those that do move out prior to closing, and this is when we were having a lot of relocation, that the summertime becomes a problem when they move out maybe 6-8 weeks and they shut off the water and the lawn goes yellow and it isn't cut, it isn't trimmed. So just for new agents to make sure that you discuss that with the other agent, the listing agent, perhaps, that they take that into consideration if there's an early move out.
Yeah, that's a great comment, great observation. Sometimes, you know, those of us who have been realtors for many years, we forget those just little tiny nuggets, which are super helpful to people that are on this class for the first time. Yeah, and sometimes if the property has been vacant for some time, you know, if I don't know, if windows have been slightly left open or doors, or there's cracks in there that can bring in some unwelcome visitors that can also make a little bit of a mess in that home. So yeah, very good. All right, let's move on. Final walkthrough inspection. So this is called the pre-settlement walkthrough. And I do like it that it does say there, final pre-settlement walkthrough inspection, because I did have a client that actually wanted to do a walkthrough after settlement, but he was so insistent we had to let him. And it was a real pain for our sellers because they were now moving out and they got boxes everywhere. And this guy wanted to come and walk through just before he was going to enter the property, which was, you know, like, I think it was a day or two after settlement. It was hard work, but it clearly says here that the final pre-settlement walkthrough inspection is there for the taking. No earlier than 7 calendar days prior to settlement. Upon reasonable notice and at a reasonable time, buyer may conduct a final pre-settlement walkthrough inspection of the property to determine only that the property is as represented, meaning that the items referenced in section 1, 1, 2, 1 to 8, 1 are respectively present, repaired, or corrected as agreed. That's generally the reason they're going to walk through, to make sure that those repairs have been taken care of, and they said they were going to leave whatever it is they were going to leave, that they're still there. The failure to conduct a walkthrough inspection or claim that an item is not represented shall not constitute a waiver by buyer of the right to receive on the date of possession the items as represented. So just important that we school both our buyers and our sellers that this is here. Often on second homes, this was not being done several years ago, but I think in today's market, this is done often. That's been my experience. Anybody else got any comments on that slide? I put a note on there to say, where possible, it's good practice for us as a realtor to attend that final walkthrough with your buyer. Well, we should do it anyway because they can't get in without us. But even if it was a brand new construction, I would encourage you as a realtor to walk through the inspection with you, or the final walkthrough with your buyer. Any other thoughts on this slide? Okay, we're making good progress here. Changes during transaction. So this is quite simple. Seller agrees that except as provided in section 12.5, which is the rented one, I believe, from the date of acceptance until the date of closing, the following additional items apply. Bear in mind, you've also got that little buyer's note there to make sure you sign. And here are the 5 points. No substantial alterations or improvements to the property shall be made or undertaken without prior written consent of buyer. That's really important. Really important. We can't change things because the buyer's buying what they've seen. So we leave it as we leave it. Financial encumbrances, changes to legal title. No further financial encumbrances to the property shall be made, and no changes in the title, that's the legal title, to the property shall be made without prior written consent of the buyer. And then we've got the property management agreements. No changes to any existing property management agreements shall be made, and no new property management arrangements may be entered into without the prior written consent of the buyer. Notice the buyer has some legal access to changes here because we're now under contract for that buyer to buy the property. Long-term lease or rental agreements. No changes to existing tenant lease or rental agreements shall be made, and no new long-term lease or rental agreements as defined in section 6A1 may be entered into without written prior agreement with the buyer. Short-term rental bookings, if the property is made available for short-term rental bookings as defined in section 6.1b, seller may not, after the seller's disclosure deadline, continue to accept short-term rental agreements for guest use of the property without the prior written consent of the buyer. So the buyer has some legal rights here. We need to make sure that if we're representing the seller, that they understand this, and they clearly understand this. Anybody got any comments on this section 12? Very good. Okay, authority of signatures. I like this. It's very simple. Authority of signatures. If buyer or seller is a corporation, partnership, trust, estate, limited liability company, or other entity, the person signing the REPC on its behalf warrants his or her authority to do so and to bind buyer and seller. So let's just make sure whoever's signing the documents, they have the authority to do so. Sometimes you may find when you're selling a property, you may think that both, maybe both the husband and wife are on the agreement of title, but sometimes they may not be. And the same when you're buying a property, you may think, oh yeah, we'd both be buying this, but maybe for some personal reasons or financial reasons, there may only need to be one of them that will have the authority to be on the REPC. Any thoughts on that? It's important you get the right people signing. That's what I'm really saying here. And also get their right names, because sometimes people are known by different names to which they sign by. Okay, so make sure you got the right names, so you got the correct authority of signers. Any comments on that slide? Okay, we're moving quite nicely. I found this little visual. I thought, yeah, we'll do a little puzzle here because it fits quite well into this. Complete contract. The REPC, together with its addenda, any attached exhibits and seller's disclosure constitutes the entire contract between the properties and supersedes and replaces any and all prior negotiations, representations, warranties, understandings or contracts between the parties, whether verbal or otherwise. REPC cannot be changed except by written agreement of the parties. For those of you who are just joining us in this industry, please understand that in this industry, everything is done by written consent. It's all signed up. I know we use electronics now to do the signatures, but that's fine, and that's all part of the game. But we don't change anything. And even if we've had a discussion verbally and both parties have agreed, we still need to put it into an addendum and still need to add it to the REPC. Any comments or thoughts or suggestions or stories on this section? Very good. Do you like this little visual I found? I thought it's pretty good, actually. I'm not sure who's doing the mediating here, but I thought it was a good little visual. Okay, mediation. Any dispute relating to the REPC arising prior to or after closing shall or may, at the option of both parties. So I thought we'd just have a quick discussion on this, because I've seen this go both ways. I've seen different brokerages have a different opinion on this. I know what our stance is with Presidio. We would generally check the shall, but I do know other brokerages that encourage their realtors to check the may option. And I know the reason for both, but I thought I'd just ask you, we've got a lot of people here with some good experience, just to ask you what your thoughts may be on whether we should encourage our client to check the shall or the may option. So let's have someone respond on that. And there's no right or wrong answer here, because there's good reasons for both.
I check shall because I'd rather go to mediation before going straight to court.
Okay.
I have heard the argument of people checking may because shall takes away their freedom to choose.
Yeah.
Yeah, I click shall because I'd rather go to mediation than straight to court.
Yeah, that's the reason I would certainly do the shall as well. There are some people that say you should put may because there may be some costs involved if you take the shall option. So I think that's some of the thoughts there. Anybody else would like to share? Linda, I'd be interested to see what you say. I think you've probably been a realtor for many years. What would you generally work with on that option?
Yes, I've been an agent for 26 plus years, and I explain both to my clients and say, how do you feel about that? But in 26 years, I've never been to mediation even. So I think it's kind of a protection for our clients, whichever one they may lean toward, letting them know they have a choice.
Yes, I think that's the key thing. It's just explain it. It's very, very clear. This is when you read through the wording here. At the end there, it says if mediation fails, the other procedures, excuse me, and remedies under the REPC shall apply. So it kind of leads you to think, well, maybe let's try a bit of mediation first, and then if that fails, we can go down other pathways. I also believe if you check the shall, you're preempting both parties. We're happy to discuss this. If we get into a bit of a wrangle on this, right from the outset, we said we might just have a chat about this first to see if we can tidy it up. Certainly mediation will be much easier than if we go down the other legal pathways from the outset. That's my thought anyway. Any other comments or thoughts on that one? And Linda, you've been over 26 years, you've never seen one of these go into action, so that's interesting as well. Good. Let's hope we don't have too many of those. Let's move on. Default. Okay, so there are some pieces of the puzzle here we probably need to just highlight. Who'd like to read that one for me? About time I had a reader. Surely I can squeeze one reader out there out of my 36 people. Okay.
I'll do it. I'll do it.
Super. Thank you very much.
Yeah. All right. Buyer default. If buyer defaults, seller may elect one of the following remedies. A, cancel the REPC and retain the earnest money deposit or deposits, if applicable, as liquidated damages. B, maintain the earnest money deposit or deposits, if applicable, in trust and sue buyer to specifically enforce the REPC. Or C, return the earnest money deposit or deposits, if applicable, to buyer and pursue any other remedies available at law.
Okay, so let's stop on that one there before we move to the next one. Any thoughts on that 16.1, or is that pretty clear? Are we all good with that? We got any questions? Or have you got any questions you think you should ask that a brand new agent might be thinking about but doesn't have the courage to ask?
I have a question.
Good.
How do you enforce the REPC on a buyer who defaults?
That's a great question. I've actually never done that, so I only know the theory, but is there someone on the class here who's actually had to do that, and what process did they go through?
I don't, but can I just ask what your name is? Because you're on your profile, it just says a number.
I'm Junie Shiotani.
Sorry, what was that again?
Junie Shiotani.
Okay, thank you.
You're welcome.
Does anybody have an experience they could share if they've actually taken someone to task with the REPC? We got anybody on this class?
I can give one, a fairly recent, within the last year, that it's the only time that it happened, that during the walkthrough, there was a snake that went across the front step.
Wow.
And the buyer was so frightened that they called their agent and said they could not buy the house because of this. It was infested with snakes. Well, the seller that lived there had never seen any snakes for 5 years plus. So of course they couldn't disclose something they didn't know.
Right.
But my clients were the sellers, and they had actually moved to the Chicago area and were intent to sue the buyer for treble damages. Of course, you can't take the earnest money and sue. You can do one or the other. And so they came up with what out of pocket, if they hadn't sold that house, what was costing them. They had moved into a rental while their new house was being finished, and it was an astronomical amount, but they were prepared to take the buyer to court. And a solution, I said, let's call an exterminator, and gave them 3 months of extermination for a snake that they had never seen. But I never saw the snake. Was there really a snake? Who knows? But they ended up real.
Wow. What a story. Okay, so that's it. It can happen. I presume the process would be that we would work for our broker and they would raise it with the board, and then obviously the mediation hopefully would take place first, and then we would have to go down whatever track that would take us to. Okay, Chris, do you want to read that next bit for me? Thank you.
Yeah. So seller default. If seller defaults, buyer may elect one of the following remedies. A, cancel the REPC, and in addition to the return of the earnest money deposit or deposits, if applicable, buyer may elect to accept from seller as liquidated damages a sum equal to the earnest money earnest money deposit or deposits, if applicable. Or B, maintain the earnest money deposit or deposits, if applicable, in trust and sue seller to specifically enforce the REPC. Or C, accept a return of the earnest money deposit or deposits, if applicable, and pursue any other remedies available at law. If buyer elects to accept liquidated damages, seller agrees to pay the liquidated damages to buyer upon demand.
Yeah, and those liquidated damages could be quite significant, couldn't they? So there is a bit of skin in the game here with the buyer defaults and if the seller defaults. Okay, any other comments on that one? Hopefully they can all keep up with their requirements that they've agreed to, and this transaction can run through to close.
Are you talking about seller default?
We talked about the seller. Yeah, they've done the default on the buyer, and there was the seller default. You got a comment on that, Steve?
Yeah, just one of the things that agents need to be able to explain to their sellers if they choose to default, because you don't have to force people to sell their homes necessarily. It rarely gets pushed through in court, but the seller will also, the liquidated damages will include the buyer's agent's commission, as well as possibly the seller's agent's commission, and any and all expenses such as inspections, appraisals, and all those things, as well as liquidated damages.
Yeah, it can certainly add up. The seller can actually be heavily out of pocket if they default. So very good. Thank you, Steve. Attorney fees and costs governing law. It basically says in the event of litigation or binding arbitration arising out of the transaction, excuse me, contemplated by the REPC, the prevailing party shall be entitled to costs and reasonable attorney fees. However, attorney fees shall not be awarded for participation in mediation under Section 15. This contract shall be governed by and construed in accordance with the laws of the state of Utah. So that's what we're going to be lining up with. Notices. Sectors provided in Section 23. All notices required under the REPC must be in writing, signed by the buyer or seller giving notice, and C, received by the buyer or the seller or their respective agent, or by the brokerage firm representing the buyer or seller, no later than the applicable date referenced in the REPC. So there are your notices. I kind of like this little visual here. I'll put a comment in here. No assigning to anyone. No assignment. REPC and the rights and obligations of buyer hereunder are personal to buyer. The REPC may not be assigned to buyer, by buyer without the prior consent of the seller. Provided, however, the transfer of buyer's interest in the REPC to any business entity in which buyer holds a legal interest, including but not limited to a family partnership, a family trust, limited liability company, partnership, or corporation, collectively referenced to as permissible transfer, shall not be treated as an assignment by buyer that requires seller prior written consent. Furthermore, inclusion of and or assigns or similar language on the line identifying buyer on the first page of the REPC shall constitute seller's written consent only to a permissible transfer. So basically here, nothing's going to be assigned to anybody unless both parties agree in writing. Any comments on that? All right. Okay, a little bit of insurance here, risk of loss. Insurance coverage. As of closing, buyer shall be responsible to obtain casualty and liability insurance coverage on the property in the amounts acceptable to buyer and buyer's lender if applicable. So that's important. Responsibility transfers to the buyer. Risk of loss. If prior to closing, any part of the property is damaged or destroyed by fire, vandalism, flood, earthquake, or act of God, the risk of such loss or damage shall be borne by seller. It's important to notice that. Make sure the seller's got their home insurance in place. Don't cancel that before you're completely off title. Okay. However, provided, however, that if the cost of repairing such loss or damage would exceed 10% of the purchase price referenced in Section 2, either seller or buyer may elect to cancel the REPC by providing written notice to the other party, in which instance the earnest money deposit or applicable shall be returned to the buyer. So there's some insurance there. There's a little bit of risk. I think it's low risk. I've not dealt with any that have had to pull this part of the REPC into play. I don't know if anybody on this class has had any experience. If they have, follow up, probably not. But it's there. It's there as a little band-aid to make sure we're covered. Let's move on. Oh yeah, make sure you've got your signatures at the bottom of that page as well. Time is of the essence. So there's a really important piece of the puzzle here. It took me a while to figure it out when I first got into real estate. So I'll read it through. Time is of the essence regarding the date set forth in the REPC. Extensions must be agreed to in writing by all parties, unless otherwise explicitly stated in the REPC. A performance under each section of the REPC which references a date shall absolutely be required by, and that's the piece that I had to figure out. I had not realized early on that everything finishes at 5 o'clock. Okay. And for those of you joining new in this industry, remember that 5 p.m. mountain time is pretty important, because all of our contracts center around 5 p.m. We had a client that was selling some land. It's quite expensive land, actually. And the buyer pulled out of the deal. Literally, you won't believe this, literally 3 minutes past 5 p.m. 3 minutes past. And I felt so bad for the poor agent that was representing the buyer, because she sent over a request to have the earnest money returned. My client, who was kind of a strong business guy, says, no, 5 o'clock. 5 o'clock was the due diligence date. And they've lost their earnest money. It was like $5,000. But that's what the REPC said. That's what it says, 5 p.m. mountain time. And so unfortunately, that poor agent would have had to maybe figure that out with her client. Maybe it cost her. My client got his $5,000. And believe it or not, with the same client, he ended up getting another $5,000 from someone. But that person didn't really care about it. They said, no, we're not interested anymore. We know it's after due diligence, we're pulling it out. So we actually got $10,000, and it was on a piece of land. The land he was selling at, I think, about $250,000. But yeah, 5 p.m. So you new agents, look at that 5 p.m. and remember, that's the time. You've got your cutoff. So if you've got a client and they've got a due diligence date that's on a particular day, it's 5 p.m. You've got to get back to the other party and say you're not playing the game. Otherwise, you're going to lose that earnest money.
Stephen.
Any thoughts or comments on that?
Yeah. Let me give you
Thanks,
another
Steve.
example, Stephen.
Yeah, thank you.
I've seen where a buyer made an offer, the seller countered that offer, and the buyer accepted the offer, and it was digitally. And then the seller received a higher, better offer. And so they sent over a withdrawal of their counter offer. But because the buyer had it time-stamped and time is of the essence of that, they basically accepted their counter offer before the cancellation of the counter offer came in. And so the seller had to be under contract with that first buyer.
Yeah.
So
very good.
That's where it comes into play.
It does. So just remember, folks, 5 p.m. Don't just remember about the date. Think about the time. Okay, let's just whistle through these last few parts in the few minutes we've got left. This one basically says that we all agree that we'll have those electronic transmissions and with our counterparts. Acceptance only occurs when basically the buyer and the seller have all signed everything that needs to be signed. Oh, here it is. That last little keyword, acceptance, that'll be the third one, ACCEPTANCE. Acceptance is that third keyword we just got in before we close up here, which is great. Acceptance is your third keyword, and they are your dates. So just be careful. You figure out these dates, make sure that they're comfortable. As a rule of thumb, I usually work within a week or so for that due diligence deadline. I try and, if I'm representing the seller, I'll have those seller disclosures. I give them on the date they agree on the actual REPC, you know, the contract, go under contract. Let's get those seller disclosures out ASAP. Due diligence, usually around a week. Financing and appraisal is probably going to be 3 weeks-ish, depending on where your lender is, and you could get the settlement done within the month. That would be a fairly swift lineup for a 30-day closing. Often depending on your lenders, will depend on how the C and the D deadlines push out. Offering time for acceptance. Remember, on this part of the contract, you're going to put in there an actual time, okay, that the seller has to accept the offer. And a question here is to think about how much time you should give them, because different sellers have different circumstances. They may be out of town, they may be at work, they may work nights, they may be in difficult shifts. So think about that, talk to the agent first, make sure you're all comfortable with a good response time, and then make sure you've got that in on this section 25. You're going to have the full buyer's signature in this section on the REPC, not just the initial, it's going to be the full signature. So make sure you've got that in there. And then you'll find the acceptance or the return or counter offer or rejection will come from the seller. And the point I'd like to make there is just make sure that you remember to put in that addendum number, okay? So if you're going to respond, make sure you put that addendum number in there. I just thought those two visuals were quite good on acceptance. And again, there we have it. The very bottom of the form, we learn again this form approved by the Utah Real Estate Commission, the Office of the Utah Attorney General, effective in September 1, 2017. So it replaces all previous forms.
Hey, Stephen.
Yeah.
Real quick, I just want to make a point on your last slide, if you go back, that it is clearly an acceptance counteroffer rejection deadline. It is not a response deadline. You don't have to respond back, you know, by that date and the deadline they give you. If you're going to counteroffer, you do not have to try to correct the deadline if you went past their acceptance deadline.
Oh, that's correct. Yes. Yeah. And they could just not respond.
Sure.
And that's
it's not a response deadline. Yeah.
Yeah. It's not a response. It's just an acceptance or, you know, a counter or rejection. But they could do nothing, and then we just default back, and we're out of the game. Okay, so basically what we've done today, we've gone through these. Make sure you get the initials at the bottom of that page. That caught me out in the early days, right at the very bottom of page 6. Make sure you get those last initials. Summary today, we basically covered all of these topics. We talked about the earnest money, the property, the purchase price. We talked about settlement and closing. We talked about the prorations, the assessments. We talked about confirmation and agency disclosure, the title and the title insurance, difference between the two, seller's disclosures, the addendums. We talked about the home warranty plan and the final walkthrough. We also looked at the changes during transaction and the authority of signers. We talked about the complete contract, mediation, default, attorney fees, costs, notices, no assignment, insurance and risk of loss. We talked about the time and the electronic transactions and the acceptance, contract deadlines, and offer and time for acceptance. They're the things we've covered today. I'm grateful for you all being with me today and getting through that, what can be a bit of a boring topic, but I think we covered it well. Thank you particularly for those of you that were able to help me on some of the reading and share your stories and comments, and value your input. If we've got any questions, we can take those now.
Could the response time be explained again, please?
Yes, let's keep you online, my dear, and we'll look at that when well, just let Leslie Ann finish up this session with some pointers,
Okay.
and then I do have our regional director with us, Steve Perry, and we'll be able to take care of that question for you. So Leslie Ann, do you want to just take care of tidying this up so people can get on with their day?
Yes, I just included the link to the Google form. Do you all see that? If you click on that, it will take you to a Google form that you'll fill out as per the instructions with your details and the keywords. Does any,
Okay.
I'll stay on here until everyone's gone. I do sometimes get people later on not understand how to get the points. So like I said, just click on that link while it's up. So if you then withdraw from the class, you've got that link.
Perfect. Any questions for Leslie Ann? Okay, we'll wish you all a super day, and we'll let you have a super week. I shall now take the one or two questions we got from the lady here.
Okay, so it's not a
thanks,
response deadline. It's an acceptance deadline. So if you're going to accept the offer, then you do it within that time frame. If you miss that time frame because of whatever reason, and you're going to do a counter offer, you just do the counter offer and everything's still legit in contract. But if you're going to accept their offer and you pass their deadline, then you'll have to write an addendum stating that you guys have until whatever time and date to extend that acceptance deadline. So that's how it works. There's no response deadline.
Correct. Does that make it a bit clearer to you, my dear?
Yes, thank you.
Yeah, so you just got to remember that when the seller receives the REPC, they can either just completely ignore it, okay, and then they're not going to be in contracts, you know, they just completely ignore it, or they can respond. If they respond within the time period to accept it, that's good. If they respond to accept it and they're past the time period, say for instance at, I don't know, 9 o'clock in an evening, and they didn't respond till the following morning, you'd have to add a little addendum that would say that acceptance was extended till, you know, whatever it was, 9 or 10 o'clock the next morning. Does that make sense? Yes, I think it does.
Yes, thank you.
Perfect. Perfect. Super. Okay, well, thank you again. And we'll see you next week, or I think tomorrow we do another different type of class.
Hey, Stephen.
You're welcome to attend. Yes.
Yeah, Christopher.
Yeah, I had a quick question.
Yes,
I actually had a phone call come in right as soon as you guys hit the section I was kind of waiting for. On section 8 of the REPC, once you get down to like section, let's see, it's 8.3 BI, when it's the financing. I've seen this kind of been tossed around as an idea lately with how kind of competitive the buying side is. If you do say if you waive your due diligence and we waive appraisal condition, but we mark financing, if, you know, I say someone's appraisal doesn't come in, can they still fall back on their financing falling apart to get out unscathed and not lose their due diligence or their earnest money?
Yeah, unfortunately, that's a tactic that's being used. Is they think they're outsmarting the seller by waiving the appraisal, but yet if it doesn't appraise, the lender's still not going to loan on a home that's below appraisal. So unless they include cash that equal up to whatever amount, right? Yeah, you could technically still get out of it because of the financing, if it is conditioned upon financing still.
Okay. All right. Yep. That's all I was wondering. Also, I might have missed our second keyword there.
Okay. Talk to Leslie Ann. She'll help you out on that.
Okay. Thank you.
Very good. Good. Well, I think we beat the REPC to bits today, so I think we're in good shape. And thanks for being with us today, Steve. Appreciate it. I shall sign off now.
Jordan's numbers, And so so it is 2.2% cap, but he's calculated on the 7.93 acres. He's not doing it on the, right? So when you do the cap like that.
I think someone was talking to someone else there. I don't think it was for us because I don't see anybody highlighted. Okay, Leslie, I'll stay online if you've got any other questions. I'm going to sign off now. Thank you for being with us today.
Hey, Leslie, are you there?
Yes.
Hey, it's Linda Hardman. You know, I've been here the whole time, but I must have scooted out to the ladies' room with that second word.
Okay, I'll send it to you.
Thank you kindly. I appreciate it. I've enjoyed the class.
I know, I actually going to tell Steve he needs to leave the keyword up for maybe a couple of minutes. So if someone does slip away to get a drink or pop to the loo,
Exactly.
that they didn't miss it, because yeah.
Thank you. I have 1 and 3, but I missed 2. Thank you.
Okay.
I also missed 2.
Yeah, you must have given that quickly.
Yeah, another person's mentioned it too. They missed the second word.
I